Administrative judges who work on immigration proceedings. They work for the Justice Department. And Justice, under Attorney General Pam Bondi, has decided that rules protecting the judges from removal are unconstitutional. This as immigration court backlogs stretch out for decades. Analysis now from University of Pennsylvania law professor Cary Coglianese. Cary, good to have you back.
Nice to be here.
And what's going on here? I mean, ALJs kind of sit and just do their thing according to established law. What's your take on what Justice is doing here?
Well, first of all, I should say that what Justice is doing here is broader than just ALJs in the immigration context. So the policy position that the Justice Department is now taking, the legal position, is that ALJs across the board anywhere are unconstitutional because they, when they are situated in agencies that have headed by commissions that have good cause protection from removal, or even given that they have protection from removal that's nested within the Merit Systems Protection Board across the board, that structure is unconstitutional as a double layer of protection from presidential removal. So the Justice Department has filed a change of position on this matter in litigation involving the SEC, the FDIC, the FAA as well. And really the position that the Justice Department is taking is that ALJs are protected from, as I said, this sort of double layer of good cause protection because the Merit Systems Protection Board has good cause protection from removal as well as the ALJs.
And
it's
let me just
a
ask
very
you this.
extreme argument.
Yeah, okay, and we'll get into the details, but just a clarification that the ALJs, as distinguished from administrative judges, for example, such as at Social Security, that hear cases of disability claims, that kind of thing.
Right. This is what their position is right now is with respect to ALJs, yes.
And didn't the SEC lose a case, I believe it went to the Supreme Court a couple of years ago, not on the basis of whether the judges are protected, but on whether the agency can be judge and jury, in a sense. And does that relate to this at all, do you think?
Well, sure. There's a stream of cases, actually, that the Justice Department, I think, is drawing its position from. Its position goes more broadly than these cases, but going back to the Free Enterprise versus Public Company Accounting Oversight Board decision from 2010, so almost 15 years now, where the court first articulated this notion that there can't be a double layer of good cause protection. So you can't have some kind of executive officers wielding significant executive power that are nested below other principal executive officers that have good cause protection. And then the court has also said that this same limitation on good cause protection prohibits Congress from insulating from removal at will agencies that are headed by a single administrator. So the Celia Law case and more recently Collins versus Yellens. So there's a stream of cases, interestingly enough, all trying to figure out what the Constitution might say about removal of officers when the Constitution itself has no words at all about removal of officers other than through impeachment.
We're speaking with Cary Coglianese. He's a professor of law and political science at the Penn Program on Regulation at the University of Pennsylvania. And the administrative law judges, I believe, in justice itself, in the immigration courts, had argued over the years about whether they are officers or employees. And this seems to put them in the employee sense and not in the officer sense, or the
Well, what would make them unconstitutional for them to be subjected to this double layer of protection is that they're officers. And what's interesting is that the court decisions to date in this regard have only applied really to the officers that are wielding executive power, and that's what makes this position taken by the Justice Department more extreme than the current stream of Supreme Court cases because it extends to officers that are exercising clearly judicial or adjudicatory powers, not executive powers.
Right, they don't have a say over what their caseloads look like or the hours they work or, the types of cases they wish to take. They're just a group of maybe several hundred to maybe 900 in the immigration system, and the cases plop down and they've got to have the hearings and decide.
Right. They don't set policy. They don't establish rules. They don't initiate actions. So this is, clearly a difference. And in fact, in a footnote in the Collins v. Yellen's case, the Supreme Court, acknowledged that adjudicatory officials are in a different category. It didn't say, what that will mean in the future. People are, I think, expecting that the Supreme Court will overturn a 1930s era decision called Humphrey's Executor that actually will eliminate Congress's ability to insulate perhaps any agency officers from removal at will by the president. The question will be just how far the court will take that, whether it will extend it to something like ALJs, whether it will extend it to the civil service more broadly, whether it will extend it to the Federal Reserve in setting monetary policy. These are really big questions, and it's hard to know exactly how far the court will take it when the issue of Humphrey's Executor and its continued viability comes squarely before it.
So then there are two basic issues. One is constitutional, which gets at the idea of the administrative state as it's grown since the 1930s. The other is the practical. You have laws on securities, you have laws on immigration and all of these other domains, and therefore you have to have a way to adjudicate cases, which means that the practical side means there could be something huge headed toward the judicial branch.
Yeah, I think on the practical side, what's most striking and troublesome about this is it suggests that the Justice Department is no longer going to have the backs of ALJs if and when there would be an instance where a president might want to remove one of them for whatever reason president wanted to. It's nothing that has to date really come to the fore as a real live square issue in terms of the removal of an ALJ. And even in the cases that are pending right now where private parties are challenging ALJ's constitutionality, the Justice Department is no longer saying that they can defend those positions on the grounds that they're permitted to be insulated from at-will removal, but they are saying that nevertheless they still are defending the ALJs and saying that, well, the private parties that are challenging them haven't shown that the removal restrictions really would have made any difference in their cases. So, the practical implications right now are rather limited, but I think also perhaps on a more symbolic or psychological level could be very deep too in what kind of message this sends throughout the government about the independence of ALJs.
So we're on fairly fresh ground here then that the administration has stumbled into, or maybe not stumbled. I think they have a plan.
I think it's of a piece with a wide range of actions that the administration is taking. It's removed NLRB officials and on policy grounds, which being challenged in court, and we'll see where that goes, probably to the Supreme Court. It's taken the position that independent regulatory agencies have to come under White House review for regulations and budgetary matters and strategic planning and even employment matters. So we're really seeing an era of the end of independence for a lot of entities, and the ALJs are now of a piece with that.
Well, as someone who's expert in administrative proceedings and in the activities of the administrative conference, could it be argued, do you feel, that, well, maybe something like the Consumer Financial Protection Bureau should be brought under because what they do has real economic effect on industries, and why shouldn't OIRA and the rest of the apparatus in